Hello, I am Jim Schaefer, a California family law forensic accountant, and I am pleased to co-present this presentation on issues related to marriage of Nelson. Kathryn Kirkland is joining me. She is a retired certified family law specialist with 40 years experience and an author for family law publications.
There are 3 parts to this presentation. The first is the Nelson formula. The second is the months versus days issue. Part 3 is income taxes. In remarriage of Nelson, the appellate court wrote, these fell into 3 separate categories: those that were granted and became exercisable before the parties separated, those that were granted before the parties separated but were not exercisable until after they separated, and those that were granted after the parties separated. This short video addresses a 4th category of equity awards in a divorce situation. This 4th category is granted before marriage and exercisable during marriage. The court's ruling on the first 3 categories is shown on screen as community, mixed, and separate. Our focus is on the 4th category that was not before the court.
On screen is the Nelson formula. The word grant is shown in red font to highlight the difference between Category 4 and the other 3 categories to make Category 4 show same information as the other 3 categories.
On screen is a modification applicable to Category 4 situations with the grant date prior to marriage. The Nelson court, quoting the Hug ruling, wrote, "We stress that no single rule or formula is applicable to every dissolution case involving employee stock options. Trial courts should be vested with broad discretion to fashion approaches which will achieve the most equitable results under the facts of each case."
The most common computation under the Nelson formula uses the number of months in accordance with the Nelson decision. The use of number of days as an alternative to number of months is equally accepted by courts.
If the computation is following marriage of Nelson, it is computed by number of months. If the computation is following marriage of Harrison, it is computed by number of days.
Income taxes are always an issue in equity award cases. Please tell us what the court ruled with respect to income taxes in Nelson.
The court in 1986 recognized that equity awards are generally taxed at exercise and subject to withholding at a 20% rate. This is not the final tax burden when the return is filed. A further complication is that the divorcing spouses are likely filing separate tax returns and may have different tax rates applied to their respective returns. In any case, counsel must refer their clients to the client's own tax advisor. The effect of the 1994 IRS ruling was to allow a court to divide the stock options in kind between the 2 spouses, thereby putting the tax issue directly in the hands of the spouses themselves and avoiding the necessity of the court having the impossible task of figuring out the immediate and specific tax consequences for each spouse. Here is my list of things to remember from today's presentation. 1. Add to counsel's checklist to review how the forensic accountant has apportioned category number 4 awards. 2. Counsel, not the forensic, must make the decision of which calculation to use, months or days, after reviewing both calculations with the forensic. 3. Income taxes are a focal point under Nelson, particularly in applying the immediate and specific rule. We hope you found this presentation a good refresher.
Please visit our YouTube channel with approximately 25 short videos on family law topics. The name of our channel is Common Issues in CA Family Law. Bye for now.